In a little more than 2 weeks, a new rule will go into effect, making immigrants who receive public assistance potentially unable to stay in the country. This morning, we are joined by immigration attorney Ral Obioha to find out what kind of impact that could have. Good morning, and thanks for being here.
Thank you for having me.
Okay, can you explain the changes from the current law to where we are now?
Yeah, so this new rule on public charge and admissibility is set to go into effect on October 15th. And now what majorly changes is the fact that as it is right now, if you apply to adjust your status, the DHS is looking to find out if your petitioner can sponsor you, if your petitioner has the ability to support you. However, with this new rule, they're going to change the focus from looking at the immigrants from looking at the petitioner to looking at the immigrant themselves. So they're going to be looking at the 7-factor test.
Now, how difficult is that going to be for someone who is already here? Also, for someone who may want to come into the country?
Well, as it is right now, it only affects, majorly affects applications that are for people who are in here, the adjustment of status application. But if the FAM decides to adopt this rule as well, it will start to affect people who are consular processing from outside the country. But right now, it's set to affect only adjustment of status applications as well as some change of status applications as well.
What should someone do right now in order to try and prepare for something like this? What can someone do so they can ensure that they can stay?
Well, first of all, I would say if you have an adjustment of status application in the works, you should try to apply before October 15, because every application after that will be heavily impacted by this new rule. Secondly, what they're looking at now is something called the 7-factor test, which is the applicant's age, their health, their family status, education, assets, period of admission, as well as the affidavit of support. So if you're looking to prepare an application now, you should be focused on ensuring that these factors show in the good light. For example, if you've received public benefits in the past, that's going to show as a negative factor towards you. But if you have private health insurance, you're gainfully employed, those things are positive factors.
Now, does this affect someone who may want to come into the country? Do they still have to prove the same thing, that they won't be a public charge at all?
Right, they have to prove it, but what they're changing, they've always had to prove it. What's new now is that the standards have changed. Instead of the petitioner who is bringing them in,
the sponsor, so to speak.
Yes, the sponsor, so to speak, or a joint sponsor, they're looking at the applicant's ability to be self-sufficient. You have to be self-sufficient. So, for example, the 7 factors has the affidavit of support as just one of the factors, as before it was the primary factor.
So really, time is running short for thousands of folks living here in the country, maybe even millions of folks living here in the country right now.
Definitely. Things are changing fast, and you should ensure that, I'm going to say to the viewers, if you're looking to submit an application to adjust status, you should ensure that your application shows the positive factors and highlights that about you so that you can prove that you're not going to be a public liability to the U.S.
Is an attorney necessary for this particular procedure right now?
As it is, things are we just don't know how they're going to, implement it. Because, for example, if you speak good English, it's a plus. So, before you apply, you should probably talk to an attorney because you might need to take some English classes if English is not your first language.
Very, very interesting situation, but at least folks need to be aware of.
Yes, definitely.
Ms. Obioha, thank you so very much.
Thanks for having me. It's a pleasure.
Sure.